Okay, so in this short PowerPoint, we'll be looking at McRae and the Commonwealth Disposals Commission. Okay. All right, so in terms of the facts here, shortly after the end of the Second World War, the Commonwealth Disposals Commission invited tenders for the purchase of an oil tanker lying on the Juramond Reef, which is near New Guinea. So they actually put out an advertisement inviting for tenders, okay? And there was reportedly oil on that tanker. McRae, acting on behalf of his company, successfully tendered for the tanker, and he entered into a contract with the CDC to buy it for £285. They then organised an expedition at considerable expense to locate and salvage the tanker at the place indicated by the Commission, and there was no tanker found at that location. And in one of the textbook readings that I've read on this case over the years, it actually said that the reef itself didn't exist as well. So I'm not sure about that part of it, but there was definitely no tanker. Now, McRae brought an action for damages on the grounds of breach of contract and misrepresentation, but the Commission argued in their defence that a common mistake had been made as to the existence of the tanker and that therefore the agreement was void. Remember, if the agreement is void, therefore it never existed, therefore there would be no potential damages claim from McRae. So that's why the CDC was leading that as a defence, because if the contract never existed, they didn't have to pay McRae for that wasted money that they'd spent, and also the contract price of that £285. Yeah, they would have only had to have returned that to put the parties back at the beginning, as opposed to potentially outlay the damages for breach of contract, which raised the idea of them having to pay for those expedition costs. So there were two issues before the court. First of all, whether there'd been a common mistake, and then the damages issue, which I mentioned. Now, in terms of the decision, so the High Court of Dixon, Fullagar and McTiernan, they unanimously held in favour of McRae, and it was found that there was no common mistake and that the contract was enforceable. And it further held that the Commission was liable to McRae for damages for breach of an implied term that the tanker existed. And the method of calculation was around wasted expenditure. Okay, right, so we'll just have a look over the page then. Okay, so in the judgment in the case, if you read it, you can see in the Dixon and Fullagar judgment, which is our main focus here, the issue around whether a common mistake had occurred was treated essentially as a matter of contract formation. And here, the existence of the tanker wasn't a condition precedent. So the contract didn't come into play if the tanker existed. On that, objective construction of on the contract, the CDC had guaranteed or promised the existence of the tanker, and they therefore assumed the risk that it didn't exist. Now, if it had have been a condition precedent, then the term, would have been fine, because in that instance, McRae themselves would have borne the risk that the tanker didn't exist, which would then have been reflected in the contract price. But that wasn't the case here. So on an objective view of the contract, the tanker was promised to exist. Therefore, there was no common mistake here. So the contract wasn't void, and the CDC was thus liable for breach of contract. And we'll come to this part in when we look at the questions relating to this case. But also another thing that was relevant in the reasoning in the case was around whether the Sale of Goods Act applied, Section 11 specifically. But for that part to be relevant, for that statute to be relevant, the goods had to have existed first and then perished. For example, if it was fruit that had been destroyed, for example. But here, it's not the case of the tanker being on the reef and then getting swept away to some unknown destination. The tanker just literally had never existed. So that statute didn't apply, which was why they were looking at common mistake as opposed to it being a sale of goods issue. Okay, so if we just quickly go through the case reading questions, so who is suing whom for what? And here McRae was suing the CDC for breach of contract, deceit and negligence. And CDC, as mentioned, they were using a common mistake as a defence. Okay, so they wanted the contract to be void ab initio. They wanted it to be void from the beginning because that meant they wouldn't have had to have paid the breach of contract damages to McRae outside of just returning the purchase price. The second question here, so the CDC argued that the contract was void or a nullity because the subject matter did not exist at the time of the agreement. In terms of the authority they relied on, it was the case of Couturier and Hastie. And at 403, Dixon and Fulliger respond to this argument, and they emphasise that this case didn't itself address whether the contract was void from the non-existence of subject matter. Rather, they noted that this case would seem to depend entirely on the construction of contract, okay? And in that instance, whether there was a condition precedent that the goods in question existed. And in that case, there was found to be a condition precedent. However, in McRae, there was no such condition precedent as noted. So rather, the purchaser had simply promised that the goods existed. In terms of the third question, so in order for the vendor to be excused from performance when the subject matter of the contract does not exist, what is it necessary that they show? It's necessary that they show that the existence of the goods was a condition precedent to the contract. So essentially that the contract was conditional upon the goods existing. If the tanker exists, then this, okay? Whereas here, there was no if something comes into being, then the contract will come about. It was simply promised to exist. So question 4, even assuming that Australian law recognised a doctrine that non-existence of the subject matter prevented its formation, of a contract prevented its formation, did the High Court accept that the principle would apply to the facts of this case? And the answer is no, they did not, okay? And this is because the mistake was the CDC's fault, okay? So the CDC's employees were negligent, and that's why the mistake was made. Okay, number 5. Why did the purchaser believe there was a tanker? Okay, they believed there was a tanker because one was advertised and put out for tender, okay? And in so doing, in advertising for tender in that way, and in using the words that they used, the CDC thus assumed the risk that the tanker was actually there. Now, looking to number 6, analyse the result of this case in terms of the doctrine enunciated by Taylor and Johnson. So I hope you've watched the Taylor and Johnson video first. So Taylor and Johnson was a case with regards to a unilateral mistake with regards to the price. If you remember, Mrs. Johnson thought she was selling her land for $150,000, but actually was selling it for $15,000, and that's what she signed on the contract. Now, Taylor and Johnson is it's a case in equity, okay? It's an equitable case. And so what happened in that case, because the unilateral mistake was found, Mrs. Johnson was successful in that argument because the other party had, induced, or there was that element of unconscionability with regards to their conduct because they knew of the mistake and actually deliberately fostered that continued belief in Mrs. Johnson. In that case, because it was brought in equity, the remedy was that the contract was voidable, not that it was void from the beginning. So for that type of principle to be relevant here, the CDC would have had to have been aware of the mistake and then deliberately sought, so had that element of unconscionability, deliberately sought to prevent McRae from finding out about the truth, so finding out the truth that the tanker didn't exist. However, that's not relevant here. Okay, so the CDC didn't know, because of their own negligence, they didn't know that the tanker didn't exist. So there wasn't that unconscionability there. They were just having a bad day in the office, I assume, their employees. Okay, now in terms of the final questions, just a quick one that we mentioned earlier with regards to the Sale of Goods Act. Okay, so when goods perish, or goods, the subject matter of a contract disappears, that's usually a sale of goods issue, okay? But here, Section 11 of the Sale of Goods Act didn't apply, and that's because the tanker didn't perish, it didn't exist and then subsequently not exist. It had never existed. Okay? All right. Thank you very much. And that is Macrae and the Commonwealth Disposals Commission.